Thank you all for joining us this afternoon. We're here to talk about obviously protecting your wealth and what the risks of doing a DIY will and how poor estate planning documents can later cause damages down the track. So essentially going through what the hidden dangers are in DIY will kits and using a damaged or outdated will. So a little bit about us here at NB Property Law is we offer personalised proactive advice to help minimise the risk and take the stress out of your next property transaction or estate planning matter. We're more than just a team of legal experts here at NB Property Law. We like to think of ourselves as dedicated problem solvers, committed to creating personalised solutions to help you guide and find a way forward. We do everything from residential to commercial property law consent, and we're also here to provide the clarity and guidance you need in your legal matters. So today's topics that we're going to go through are what are the common pitfalls that we often see with the DIY will kits that are out there and the generic templates that are used. We're going to speak about how damaged, unclear or missing wills can create legal complications, when and why you should actually update your estate planning documents. We're going to go through what the key considerations for creating a plan that reflect your current wishes, and also speak about how to safeguard your investments and your family from future disputes down the track once you're passed away. So to begin with, we're going to talk about what actually makes a valid will. So for a will to be considered valid here in Queensland, it must be in writing. It needs to be signed by the testator. So this is the person that's actually writing the will or the person that passes away, or someone else in the presence of and at the direction of that testator. So, whether they've given authority to someone, through an attorney or something like that. The signature must be witnessed in the presence of 2 or more witnesses for it to be legally binding, and the testator must sign with the intention of actually executing that will. So it can't be under, undue influence or anything like that they've actually signed off on the will. So what is actually the benefits then of having a will in place? So obviously, we want to be able to preserve our assets. Over the years and over your lifetime, you work hard to build up your asset portfolio, and you want to know that they're going to who you wish for them to go to. So it also allows you to actually donate some money if you choose to charitable purposes, if that's your intention, rather than just leaving it all to particular beneficiaries, children or family, friends, and things like that. Having a will in place can also allow you to establish a trust to provide for your children or a beneficiary with a disability. So this is what's known as a testamentary trust, which basically operates and only will come into existence once that testator passes away. A will provide certainty as to what you want to happen after your passing, which can obviously then assist with, taking out any disputes. While anyone can obviously dispute the will, it does provide that clarity needed as to who you wanted to leave your assets to and how. It can minimise the stress for your family and friends, so they're not left with the burden of trying to, work out, what it was that you intended to be the distribution of your assets. It can also reduce the cost to actually administer your estate. So, without a will, it can lead to more disputes, and then, that can then eat away at the proceeds of your estate. And as I mentioned before, it's going to limit that likelihood of dispute with your will in place. So there are what's known as DIY or do-it-yourself will kits out there, and some people will from time to time use those will kits, but, they do come with risks of using them. Why, you can go to the post office and get a kit to do that up, or I think the news agencies and things even sell them. Are they even binding, I suppose, is a big question. In theory, yes, they are. However, with wills, it's not one size fits all approach. So, each will that we do for a client, we have to go through a series of questions and gain instructions from individuals as to what their situation is. It's not just a clear cookie cutter document that we're drafting. Each person has different situations. Sometimes there's blended families. Sometimes there's people that they want, excluded, where, they've, no longer have contact with children and things like that. So it's not one size fits all. And so those DIY will kits, we've seen issues pop up with them in the past. For example, I've had clients that have used them and, it hasn't been witnessed correctly. There hasn't been like a backup layer, for example, for an executor, and therefore there was no executor, so it's therefore not binding as well. So different things like that we see from time to time, which, render them, to be used very much with caution because, you just don't know when those issues will pop up. So, I mentioned some of them just then, other things where they've not been completed correctly. Sometimes we see that they're not including provisions to outline what would happen if a gift fails or a beneficiary passes away before you. So, with specific gifts, they need to make sure that they're, as the title deems them, they're very specific. So that gift needs to be available once that person passes away. If it's not, that leads to issues. Again, the same with beneficiaries. If we don't have backup layers for beneficiaries and that person passed away before the testator, again, can lead to invalidity of the will. Sometimes these DIY will kits as well, they lack the flexibility to actually accommodate what your actual situation will need. I mentioned the signing and witnessing. Sometimes that's often a thing that's not done correctly. And also the gifts of assets not actually owned by the testator. So, it might be owned by a company or a trust as opposed to the actual individual testator itself, which again is not going to help the situation. It could likely lead to the will being deemed invalid if it's done by this DIY will kit. So what happens as well with damaged or destroyed wills? So, maybe we've done up a will correctly, but, over time we've not looked at it for a while, or we've not had it in a safe place and it becomes damaged or destroyed. I will say when we do draft our wills, we often like clients to allow us to keep it in what we call safe custody. So we keep them all here for clients in this safe custody. We always tell clients to let the executor of the will know that we've got them and our contact details. So when the time comes that they do need them, they can obviously contact us for that original copy, because often if, they are left with individuals, they can get lost over time. They can become damaged, you not put them in a safe place and, coffee spilt or something like that on them, which could lead to it being, deemed invalid as well. So when we're drafting up wills, it's important to understand, what is considered valid and what the courts would deem as damaged or destroyed will. So it's important that wills don't have any staples holes in them. So, that's obviously going to show that, a will has been made, someone's ripped out staples, potentially replaced a page with something that wasn't actually agreed by the testator, so that the courts won't accept that. They're also not going to accept anything that's got tears in it, like I said, water damage, copy stains, things like that. If there's been handwritten writing on the original will as well, it won't be accepted. Any rust marks as well, often where paper clips have been used to bind the documents together and potentially removed. Anything that basically indicates that the will may have been altered from when it was signed is going to be considered as damaged or destroyed. So it's important to understand this because when applying for probate in Queensland, which means, once the person has passed away, the testator's passed away, often you may have to apply for probate through the Supreme Court, and they do require that original will. And if it is considered damaged or compromised in any way, as to any of these situations that I've mentioned here, the court may need additional evidence to ensure that the document still reflects the testator's true intentions were. So even something, like as simple as I said, removing the staples or paper clips can cause suspicion for the courts, and they're going to be doing the right thing by looking for these signs that a will has been tampered with or revoked. And so any indentations, staple holes, things like that can mean that, they're just going to be saying that the will's not valid, or it's going to be more costly for litigation to see and prove that it was actually a valid and legally binding will. So it's important with our wills, once it is finalised and fully signed, witnessed, that we don't, try and repair it. If we've ripped it, there's no point putting sticky tape on it or anything like that. If we decide we want to change something, there's no point hand writing it, that change on the will. You need to get in contact with your solicitor at that point to get a new will drafted up so that it is intact and it is seen as valid by the courts. We need to be collecting evidence as well, statements potentially show how the damage occurs. So, maybe we can't do up a new will because the testator's passed away. We need to make sure that we're, getting those statutory documents and affidavits and things in place to show that what's happened with the original will and why it has become damaged. So an affidavit of plight or condition of binding is what that's called, and that will then be filed with that probate application with the courts, and the original, which could be a damaged will at that point in time. So the courts do still have the power to grant probate of a damaged or even lost will, provided there is enough evidence to prove that the will actually existed and was still validly executed, and that the testator did not intend to revoke it in any way. The terms of the will can still be clearly proven as well. So this often requires that at least one or more affidavits, which is what I've mentioned here, from the people who saw the will, such as that could be the drafting solicitor or either one of the witnesses. So in many cases, this affidavit applied or this condition and binding is used to explain the situation to allow the courts to still proceed with the damaged will. So I suppose what is actually considered a revoked will then? So this is when we actually do up a new will. So if you burn, tear, or otherwise destroy the will, but it must be done with the intention to actually revoke the will, so that original will, and you write or deal with the will in a way that satisfies the court that you wish to revoke that original will. So a marriage or divorce or ending a civil partnership, that will automatically revoke a will. So, if one of those situations has occurred and you haven't done up a new will, note that original will you had done, prior to marriage or divorce or ending a civil relationship won't be valid any longer. So it is important to get a new one done up at that point in time. So when should you actually update your will then? So we often recommend that you at least review your will every 5 years. Things change over that period of time, and, it's always good just to refresh your mind as to what your situation is, what you've got in place. So we need to look at, if you do start or end a de facto relationship or marriage, as I mentioned before, that's going to automatically revoke a will. So we want to get a new one done up at that point in time. Maybe there's been a birth of a child or a grandchild that we want to add into the will. Sometimes, financial situations change. That's always a good time to look at updating a will as well. If an executor or beneficiary under the will has passed away, while we might have second layers, it is always a good idea to update the will at that point in time, so we then still can put in a new backup option as well. If you want to change your executor or the beneficiary nominated in your will, then again, of course, we still need to update your will at that point in time as well. So key considerations for actually creating a plan that reflects what your current wishes are. So who do you want to actually appoint to administer your estate after you pass away? So this is known as the executor, sometimes also the trustee or the administrator of your will. So they're responsible for basically, as the name suggests, administering your estate. So, doing all the paperwork, applying for death certificates, applying for probate, distributing your estate to the beneficiaries that are listed. A lot of the admin procedure is left down to that executor. You can have multiple people appointed as executors, so you might have them acting jointly as executors, or you might appoint executors successively. So like I said, having one person listed, maybe the spouse, if they're unwilling to do that role, then you might have brother, sister, mum, dad, something like that as that second layer. We also want to look at, do you want to leave any specific items to anybody? So this could be a set of money or some jewelry or watches. Family heirlooms, obviously a big one. As I mentioned earlier, though, with specific items or specific gifts, more commonly as they're known as, we need to make sure that specific gift is actually available at the time that testator passed away. Otherwise, as I mentioned at the start, that can lead to issues if we don't have that specific gift available, but we have actually listed it as a gift in the will. Who do we actually want to inherit our estate? So these are what are known as the actual beneficiaries of the estate. So, they're the ones that are going to benefit from the estate. And, again, we can have multiple layers. So often, in a generic situation, it might be a spouse. And then as a second layer, it could be the children. In that situation, we obviously If it's a younger family, they're all still living together, we often will like a third layer as well, so that, if something horrific that would happen, they're all in a car accident or some type of accident, that we've still got then another layer as well. The other thing we often include as well, sometimes if people aren't updating wills as regularly as we like, is that, for example, if we were to leave it to the children, it could be that if the children were to pass, their inheritance would go to their children, which would be the testator's grandchildren as well. In the will, we'll also identify any unique circumstances. So, I mentioned at the start, there may be a family member that we don't talk to, known as an estranged family member. We don't just want to simply not include them in the will. We need to, for the court's purposes, outline that we've actually acknowledged that we do have this family member, but they're estranged, and for that reason we don't want them to benefit from the estate. And therefore, if that estranged family member were to contest the will, it can be clearly demonstrated and outlined that they weren't forgotten or missed, they were intentionally left out of the will. We also will draft into the will as to what we want to happen to the testator's body after they pass away. So do we want to be cremated, or do we want to be buried? And you can go further with what's called a letter of wishes, and include things such as where you want your ashes to be spread and things like that. That wouldn't be included in the will per se, because it's not something that's legally binding. We can't enforce that the executor were to carry that out. So we would put it in a letter of wishes, and that person that's appointed as the executor, we would expect that that's someone like and trust anyway, and they would carry out that wish for you. With the letter of wishes, like I said, it's a non-binding document, but it just outlines exactly what you want to be whatever it is that you want to be your intentions. So as also listed here, your expressed intended funeral arrangements, that's something that would also go into a letter of wishes. Included in the actual will, though, we can stipulate whether you want to leave gifts to charities. Again, it would be quite specific as to what that gift was and the actual charity that we're leaving them to. We go so far as to even say, should that charity not exist at the time you're passing, then, that money goes to, maybe there's a subsidiary charity or something like that, so that we cover off on all bases there. Now, probably a lot of people know the Public Trustee in Queensland. So they are a government organisation, and they do wills. You may be inclined to have your will drafted by the Public Trustee, or maybe you've already got one, because they offer what's people perceive as a free will drafting service. However, I think a lot of people don't realise that while they're not paying the Public Trustee to draft the will up front, the way that the Public Trustee collect their fees is after the testator passes away. They charge the estate basically for their services. So with the Public Trustee, they have to be appointed as the executor, and then their role in acting as the executor is how they basically obtain payment for their services at that point in time. So there's obviously, can be some cons then that come with having the Public Trustee draft your wills. I suppose looking at a couple of different situations where, we've got someone that's had the Public Trustee draft their wills, and they've got another fictitious client that's gone to a private lawyer and had their lawyer draft that will up. So in the first situation, we've got Daphne, who decided to go to the Public Trustee and have her will drafted with them back in the 1970s. Now, she passed away in 2018 and left behind 3 children, all living here in Brisbane, that would actually inherit Daphne's estate. So she had one bank account with the CBA and needed to be refunded her nursing home bond. Maria is our other situation where she's gone and have a will drafted with a private lawyer back in 2015. Now, she's passed away in 2021, and 2 of her children and 4 of her grandchildren, all living in different states across Australia, were the beneficiaries that would inherit Maria's estate. She had 2 bank accounts with CBA and also an international pension that needed to be refunded along with her nursing home bond. So in the situation with Daphne, although the cost up front for the Public Trustee drafting the will was actually free, in the overall scheme of things, the estate administration, which had to be done by the public trustee as the executors, ended up costing her $7,000, and the duration to administer the estate was 1.5 years. We often see that with the public trustee. It's a bit of a slower process. They've probably got quite a big workload of state administration work that they're doing for their clients, so it can take a lot longer to get through the administration. So it then means that the beneficiaries are no longer getting their inheritance, and at the outset it's taking some time before they can actually see that money. Maria, our other situation, who she'd gone to her private lawyer to draft her will, ended up paying $900 plus GST to draft those documents at the outset. And then the estate administration costs to help get her private lawyer to assist with the probate application was $2,500. So, she's only spent $3,400, and the duration it took to administer the estate was only 6 months. So, you can see there's quite a big difference there. While we think, and most people think, they're getting a free service from the public trustee for drafting that will, the cost does come afterwards. And unfortunately, often the case is as well, it's a much longer process for the estate administration process to be concluded once the testator's passed away. So I suppose, why should you then have a lawyer drafting your will as opposed to doing your DIY will kits? It's obviously a good idea to get a lawyer to draft your will, as they're going to keep detailed notes of what the conversations they've had with you. We're always writing file notes whenever we're speaking to a client, or we've got email trails that we've saved them as well, outlining different instructions our clients give us. This is obviously going to help to assist the family and friends and the court if needed, if there is any doubt as to what was intended for you as the testator to be your instructions. As lawyers, we will always draft the documents, but actually explain them to our clients in a way that's easy for them to know what we're writing, what it all actually means. And if you've got questions, we're obviously here to answer them, or any concerns you have prior to creating a will, or even down the track, you maybe have done the will and signed up already, but some situations change, and you need to know, do I need to update it, or should I update it, or how do you go about updating it? As lawyers, we're also aware of how to best preserve the will. So like I mentioned before about the way a court will consider a will to be damaged or destroyed, we know how to best preserve that. We've got safe custody here that we keep all our wills and estate planning documents in, so that they can be called upon when needed and the time comes. And also, we're aware of what the court's high standards are with keeping those documents. A damaged will, while it can still be deemed valid depending on how damaged it is, we know that we've got to have the documents to go along with that, and statements by the people involved to consider it as it's still a valid, legally binding will. So an invalid will or no will. So what are the difference where it's considered invalid, or if you've got no will at all. So if that is the situation, you're considered to have passed away as what's called intestate. So this means that your estate may not be distributed to the beneficiaries in accordance with what your actual wishes are. So this stress can be made worse when there's no valid will in place. So having no valid will can cause extended delays in distributing the estate, as the rules for dealing with an estate with no will have strict rules to follow. So therefore, it's always important to remember and understand the rules surrounding intestacy, and dying with no valid will in place is always good, and we would not recommend obviously not having a will in place. So your next step, and our gift to you, to thank you for joining us as part of this session, we're actually offering a complimentary will and power of attorney review to everyone that's here with us today. So as a bonus, if you'd like to scan this QR code that you can see on the screen, you'll actually get a checklist of basically estate planning preparation, and to give you a clear and confident idea of what you need to actually start drafting your will. Let us know if you need help, and we can take any of the guesswork out. It's needed to protect your matters the most. So we're happy to offer a complimentary consultation with you today and NB Property Law by scanning this QR code, and we can talk to you about what your situation is and what you need to basically ensure that your estate planning needs are up to date and that they're protected and your assets are going to who you choose for them to go to. So that's a bit of a nutshell, talking about, the risks that we have with the DIY will kit, why it is important to have an actual lawyer draft a will, and what happens if we don't have a will in place. So talking about those intestacy rules that apply to a deceased estate with no valid rule. I don't think, anyone wants to be dying intestate. We've worked hard for our assets. We want to make sure that they're going to who we've actually chosen for them to go to. So I'll open it up now for any questions. If anyone's got any questions, if you want to either put them in the chat box or feel free to take yourself off mute and I will answer them now. Otherwise, I've got my contact details up there as well. Feel free to give us a call or email and we'd be more than happy to have a chat with you further. So I'll just give it a couple of moments if anyone wants to ask any questions. So I've got a question here. Is there a need to register a will? So in Queensland, there actually is no will register. We don't have one at all. If a will is lost, you can advertise for it in the media that it's, newspapers that it's been lost and see if one's available to find that lost will, but there is no register of wills. You can register a different estate planning document, the power of attorney, with the titles office. The powers of attorney, you only register them if the attorney was dealing with property for the person in that situation. But we actually don't have a register of wills, and so therefore the answer is no. There is no need to register a will here in Queensland. So what is the typical cost for a simple will? Here at NB Property Law, so we do charge for a basic will for someone. You're looking at around 900 plus GST, but again that depends on the situation. That's a basic will. Sometimes we've got to look at someone's situation. That's basic. Someone that has companies, they might have family trusts and things set up. We need to do a more complex will because we've got to take them into account. We've got to review, company constitutions. We've got to review the family trusts and make sure, we're appointing an alternative director, alternative shareholders, an alternative appointer of the trust in place, because a lot of the times, assets are not owned by someone individually. They're owned by these companies or these trusts. So that makes it a more complex will. So it depends on the situation there. Someone's put, how can you stop a stepchild from claiming more than they are willed? So, I did briefly speak about like blended families. So again, having a will in place is going to make sure that we've clearly outlined what our wishes are. So if we don't want to leave any money to a particular person, that's fine. They might not be estranged, but we still want to make sure that they're listed and the reason why we're not leaving money to someone. We don't necessarily have to leave equal amounts, so to two people either. Maybe you are wanting to leave some money. I think they're saying claiming more than they are willed. So if you want to leave something to the stepchild, that's fine, but you doesn't need to be an equal split as well. We just need to clearly state, that would be a specific gift then. We're leaving them X amount of money, or maybe it's a property or a gift or something to that value. It just needs to be put into the actual will itself. So today's talk, someone said, is it specific to Queensland or is it relevant to Victoria as well? While I'm a Queensland lawyer, we have, each state in Australia has different succession planning acts, which is what dictates and how the jurisdiction for estates and plans and wills are worked out. However, they are very similar. So what I'm talking about today is probably very relevant and very similar to what Victoria is. There may be some slight changes, but generally across Australia, the wills all operate in the same way. However, I would recommend with your estate planning, so with your wills, and if you want to get a jury power of attorney done up, that you get that drafted in the state that you live in or the state where you own most of the assets as well. So if you're in another Victoria, for example, but all your assets are located up here, and maybe you're just down there for the short-term period, you're probably better off doing a Queensland will. But if you've always lived in Victoria, everything you own is down there, then you would be best doing up your will in Victoria. So it says, does Queensland have an inheritance tax on money, property or assets and super payout, including insurance payout through super for accidental death? Now, probably something best to speak with your accountant about. But understand that if you are inheriting money or property, you're not going to be paying tax. So particularly like for property example, if we're transferring a property to a beneficiary listed under a will, they're not going to pay things like transfer duty for that property that they've been inherited, and so that is a benefit of having the will. We've had, for example, where there was no will in place, and the brothers, there was a few properties, and one brother wanted one property, the other brother wanted two properties, but however the laws of intestacy, it each needs to be a simple split. So although they'd mutually agreed on that, by not having the will in place meant that they were going to be liable for transfer duty and things like that. So having that will in place, if they had have had that, it would have avoided the need for them to pay that transfer duty tax. But still best to check with your lawyer on it. I think as well it's different when the beneficiaries are located overseas. I think there's sometimes tax implications that can come into place then. But again, best to have a chat with your accountant about that. What does probate of a will mean? Is it a compulsory process? So it means basically it's the administration of the estate. So once a person passes away, the court needs to deem basically that the will is valid and legally binding. Not every estate needs probate. It depends on what the assets that they own. Sometimes as well the bank. So sometimes if there's money in the bank, sometimes banks will have a certain threshold. For example, Westpac might, I won't even say a bank because each bank is different, but one bank might say that if you've got over $150,000, you need probate to be able to distribute that money to the beneficiaries. So it depends on different banks, different situations with properties and things like that as to whether we do need to apply for probate or not. So it's compulsory, I suppose, in certain situations, but it's not necessary always. It does come down to the individual circumstances and the assets that they own. If I have assets in Ireland as well as in Australia, do I need two wills? So there is what's called like an international will convention, that there's some countries that are signed up for it. I don't know that Ireland is one of them. And for it to be an international will, it needs to have certain provisions in it. So, if you are having that will drafted, I would check with your solicitor as to whether the island is part of that convention. And obviously there needs to include specific clauses to allow for that. Generally, though, there's not many clauses that countries that are part of that convention. I think there's only around 32 currently that are part of it. And therefore, if they're not one of those countries, you would need two separate wills to deal with if you did, have assets, as you mentioned, in that other country. So, but they would still need to recognise that you have two wills in two different countries so that one, wouldn't delete the other per se. When you do have international assets in different countries, you may end up with multiple wills, but it's still important that each of those wills recognise those other wills as well. Wondering about property. If you have a shared property and a difficult relationship, if they pass before you, can their will, I think, leave half of the property out from under you or someone else? So with property, now your will's going to basically cover off on everything. Super is separate, so you do need to have what's called a binding death nomination with your industry super fund. With property, though, it potentially will cover property if the property is held as a sole owner, if it's someone that owns it solely. If the property is owned with someone else, you can either own the property as joint tenants or tenants in common. Now, if you own the property as joint tenants, the will doesn't come into it. It just means that the person that survives the other property owner, sometimes there could be multiple, they automatically then get your share of the property. However, if at the time of purchasing the property you decided to own the property as tenants in common, you can own different interests with tenants in common as well. Joint tenants means it's just a split equal ownership. Tenants in common, you could own, someone owns 20%, someone owns 80%. But if one person passes away, the will then dictates what happens to that person's passed away share. So, if you were in a maybe difficult relationship and you do own the property as tenants in common, then yes, that person could have a will that says that, yeah, you're not going to get that share of the property. It's going to go to whoever's listed as the beneficiary in the will. Just following up from that question about the Convention for International Wills, we do have an article on our website. If you do search in the research hub for international wills, it will give you, go through more information about what that international will convention is all about. Otherwise, yes, feel free to send me a quick email and I'll send you a link back to that as well. Another question is a prenuptial agreement valid in Australia so that I can have a will drafted without being affected by a potential collapse of marriage? A prenuptial in Australia, we don't term them that per se. It's what's called a binding financial agreement, and they are generally drafted by a family lawyer. They do need to be very watertight, so it is important to have them drafted correctly at the outset. And they can, assist with what would happen, if there was a breakdown in a relationship, per se, who would get what, in terms of, so that I can have a will drafted without being affected by. So yeah, you would still have a will, because the nuptial is what you've called it, but a binding financial agreement's only dealing if there was a breakdown in the marriage, not if someone was actually to pass away. I would just give it another minute to see if there's any other questions that pop up. I don't think there's any other further questions in the chat box. If you do have a question though, wait there, we've got one more popped up here. Is there tax on super for beneficiaries when received? So again, I don't believe, I would check this with your accountant, I don't believe that you pay tax on any inheritance, which would include super, but the important thing to note is, I mentioned before, is super actually does not form part of your will. So even if you do have a will or you don't have a will, you still need to contact your industry super fund, or if you've got self-managed super fund, to have what's called a binding death nomination put in place. Those binding death nominations, they're generally lapsing as well. So they generally only last 3 to 5 years. So if you don't think you've done one recently, important to check with your super fund as to when it's valid to, and making sure that you get that updated if needed, and that you diarise the date as well when it does lapse, so that you can continually update that binding death nomination to deal with super. If, for example, you didn't have a valid binding death nomination with your super company, but you did have a valid will, they would often look to what you had listed as the beneficiaries in your will to decide, who the super fund money would go to. But like I said, it's an asset that doesn't form part of your estate. And I've got another question there. Will we send these presentation documents to attendees? We certainly will be. We'll send the presentation slides along with a copy of this recording, and we'll also send a checklist as well as to what you need to prepare for actually getting your estate planning documents put in place. Just give a couple of seconds, make sure there's no last minute questions popping up. Right, we might leave it there. Thank you everyone though for joining us today for our webinar on estate planning, and obviously the risks of having DIY wills, why you want to have a professional solicitor draft that, and the importance of making sure that wills are not damaged. If you've got any other questions though, feel free to reach out to us. Like I said, we'll send through the slides, the recording and a checklist, but happy to go through and answer any specific questions you might have via a complimentary consultation with you. So contact details are up on the screen still, otherwise you'll get them in an email that follows, and we'd love to hear from you. But have a great rest of the day, and thank you all for joining us.